hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others, as always. I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are in the Court of Appeals on the ongoing appeal of Johnny Depp versus Amber Heard. As we will recall, there was a lawsuit between these two over mutual claims of defamation, and the jury awarded mutual awards of defamation. They awarded Johnny Depp $10 million, $10.3 million, and they awarded Amber Heard $2 million. And we have covered some of these briefs already in these competing cases, and there are some more briefs to come, of course. But for tonight's episode, we are dealing with the reply brief. This is the third in the sequence, right? So we have the reply brief of the appellant. So this is, normally you have the initial filing, and then you have the response, and then you have the reply. All right. So this is the third thing in that particular sequence. And because they both filed appeals, they both get responses and they both get replies. Anyways, we are going to review the brief of Johnny Depp responding to Amber Heard. Because Johnny Depp's like, here's a whole bunch of reasons we should win. I thought issue 1 was best issue. I thought issue 4 was, best issue or second best issue. And then, we have some other things that are not so great, issue 2 and issue 4. But we're going to see what Johnny Depp and his team does with this. So here is the reply brief of the appellant. That is Mr. Depp. And here are some things that he would like to talk to the jury about. So we have Miss Heard mischaracterizes jury verdicts and findings. Definitely had plenty of that. Miss Heard's reliance on vicarious liability based on agency is inappropriate in the attorney-client context. I tend to agree. An attorney is properly understood as non-servant agent. Yeah. Miss Heard's vicarious liability theory is particularly inopposite in defamation. I'm not sure if it's particularly inopposite, but I'm willing to be persuaded it is particularly inopposite. Miss Heard did not establish that Depp directed, controlled, or authorized the statement. There are some problems there. There are definitely some problems there with that because a lot of those questions were protected by privilege. And so there is a bit of a factual problem. Like the jury is allowed to, if we're thinking about this from what a jury is allowed to do and a jury is not allowed to do context, right? A jury is allowed to find all facts and all inferences that are available from those facts. So the jury is provided a whole bunch of possible competing facts. They are presented with a whole bunch of witnesses. These witnesses may at times contradict each other. They may be mutually incompatible. And regardless of whether they're mutually incompatible or not, the jury can believe them or not. So just because they're not contested doesn't mean the jury has to believe that either. So even if you had something that one party says the other party doesn't contest, even if you had both parties saying the same thing, the jury doesn't have to accept that, right? The jury is the finder of fact. So they can accept any fact or not, or any inferences that's available from those facts. What a jury cannot do is merely speculate things into existence. So there is a line between inferring from the available facts and speculating into existence facts that weren't provided. And so that's what he's talking about, that this is reaching into that speculation territory because a lot of what happened between Depp and Waldman is protected by attorney-client privilege. A lot of the questions were not answerable because of attorney-client privilege. And so you don't have Depp commanding Waldman because, well, those are privileged. And so the jury didn't hear it. So the idea that maybe we're on the wrong side of the line, maybe that we've moved from a place of permissible inference to a place of impermissible speculation is not exactly a bad idea. So that's definitely a possible we might be on the wrong side of the line idea. Ms. Heard failed to establish actual malice, required to show Waldman made the statement with actual malice. Okay. Failed to show that Waldman made the statement with actual malice. Do you have to show that Waldman had actual malice, or was it enough that Depp had actual malice? I'm not sure, but we'll see. The statement is properly understood as opinion. I'm not sure about that, to be quite honest, but we'll give it another go. The court should have instructed jury on independent contractor theory. Perhaps. And the trial court should have admitted the entire April 27th article, which is fourth issue, which I think is not bad as a backup issue, because I think the article itself is probably not hearsay within the meaning of the law, because it certainly contains a lot of out-of-court statements, but it's not being offered for the truth of the matter asserted. It's being offered for the context in which the statements were presented and how those have impact on the listener, which means that it doesn't mean that they have to be true or not, right? Nothing else in the article has to be true or not. It doesn't matter whether they're true or not in some respect, because what the people read was the article. What the other things contained is what their truth value is irrelevant. Like, they could all be lies, and the juror and a person reading the article would still understand the statement in the context of the lies. So you're not offering it for the truth of the matter asserted. So I think saying that you need, and also in defamation, context is king. So if you're looking for an error in an evidentiary issue, this could be it. It's like, yeah, this is arguably the key piece of evidence for Depp, right? The article is arguably the key piece of evidence with respect to the statements that Depp/Wallman uttered, because they were uttered in the article. So it is the key piece of evidence. So keeping it out, right, is a question of discretion. But since it's the key piece of evidence, abuse of discretion is not impossible in this context, because it's so central and so important that, it's not something we can just kind of whoopsie past, right? Because there's nothing else that can really replicate it. It is the key thing. It's not like we somehow had someone else come in and testify about things, so no harm, no foul, right? It's kind of a big deal. So that's sort of what that's all about. But let's read some more. All right, so we got some statements of law. All right, so in the appellee brief, Amber Heard misapplies the law, misstates the findings of fact, attempting to distract the court by re-arguing factual disputes the jury emphatically resolved in favor of Depp. Yeah. Again, the jury is entitled to an extremely wide range of discretion, because they're the finder of fact. If you're going to argue like it's against the manifest weight of the evidence or something, like the evidence is so overwhelming that no reasonable juror could come to this conclusion, because while there might have been some evidence that kind of supported it, the overwhelming weight of the evidence is so weighty that no, which you can kind of do, right? Because the jury is allowed to like accept and reject facts. So, if you're going to argue some sort of overwhelming weight of the evidence theory, it's got to be pretty overwhelming. And no. So in lieu of that, the appellate court will accept that the jury found every fact necessary to support the verdict, because that's what they do, right? The jury must have found every fact that would support the verdict. They must have found every fact that would support it. They must have disagreed with every fact that goes against it. I mean, that's not necessarily true, but that's the presumption we go in with, right? Okay, so in fact, this appeal presents the court with only a few narrow legal issues, each of which warrants the reversal of the lone portion of judgment in favor of Heard on a counterclaim. First, can a client be vicariously liable under a pure agency theory for alleged tortious conduct of an attorney? Longstanding principles limiting liability for acts of independent contractors dictate no, when, as here, no evidence of additional tortious conduct by the client was presented. So if they're not your agent, if they're not your employee, rather, I misspoke. If they're your employee, respondeat superior. If they're not your employee, if you directed it, then directed it. But you don't have direction because everything was privileged. And you probably don't have employee-employer relationship, both as a matter of fact, in reality, and as a matter of law. Second, did Heard present any evidence to show that Waldman made the statement with actual malice? Again, the answer is no. Heard presented no evidence, much less clear and convincing evidence, which is the relevant standard for public figure or public matter defamation in Virginia, mind you. That might be a requirement by in federal law too. But clear and convincing evidence is the right standard of Mr. Waldman's state of mind. She argues she can fill in the blank of evidence with Mr. Depp's state of mind, but not so much. That's a problem, right? If he's not an employee, you can't do that. And if he's in it, yeah. Regardless, Miss Heard presented no evidence that Depp even knew the statement had been made, much less contemporaneously knew it was false. That there is definitely some problems trying to get yourself to that position, to be sure. I'm looking for continuous scroll, by the way. I just don't know where it is in my setting. I'll keep moving on. Third, in context, should a comment by Waldman to well-informed journalists about inferences to be drawn from conflicting evidence in a contested litigation be properly understood as a factual statement? Okay. So, okay, because he's an attorney and he's an advocate, they should be properly understood as opinions, not facts. Okay, I'm up for this possibility. Let's give this a roll. For the third time, the answer is no. The Waldman statement in context is nothing more than theory proffered by a speaker with disclosed bias, discussing an interpretation of ambiguous subject matter about which he claims no first-hand personal knowledge. Ooh, okay. So we want to try to argue. Okay. All right. So we're trying to argue this proposition. Now, let's start with basic principles before we get to the specific proposition we're trying to argue, right? Is it possible a statement that appears to be a statement of fact is nevertheless a statement of opinion? Yes, it's possible. Also, the reverse. Is it possible a statement that appears to be a statement of opinion is in fact a statement of fact? Yes, it's possible, right? Now, normally we see this more in the context of opinion being understood as fact, because that's like what defamation by implication is a lot built on, right? It wasn't what we said, it was the implication. The literal text on the page is not defamatory. What is defamatory is the implied facts the statement conveys, whether it's a statement of opinion that conveys hidden facts or a statement of fact that conveys hidden facts, right? So the facts are not the facts that appear on the page, if they appear at all. They're the hidden facts that are assumed, that are understood by the reader, right? So can a statement of opinion be understood as a statement of fact? Yes. Can the reverse be true? Yes, it is possible that you have a statement of fact, the statement that appears to be a statement of fact, but is nevertheless a statement of opinion. And a good example might be a statement that is a statement that is so what would you say? A statement that is so wide in its understanding that it doesn't convey any particular factual allegation. For example, if you said person X is a racist without more, right? Without more, just the naked statement, person X is a racist. The overall weight of the court authority says that that statement is not a statement of fact, right? It might on some surface level appear to be a statement of fact, right? You're saying he is in fact a racist. But the thing is, the term racist has been understood by the courts, again, without more. If there's more, the analysis changes. But without more, the statement racist is understood to be so wide as to be a matter of opinion. Because what makes someone racist or not is a little bit in the eye of the beholder. So that might be an example of a statement where it appears to be a fact, but isn't a fact. It's actually an opinion, as understood by the courts. So what they're trying to do here is, from those general principles, what they're trying to do is they're trying to take the idea that opinions can actually be facts and facts can actually be opinions, which is a proposition that is understood to be true in law. They're trying to take that proposition and then say that Waldman's statements, which I think to be, at least in my opinion, are on their surface statements of fact, are actually best understood as statements of opinion. Like, so that the trick didn't work and Amber Heard spilled a little wine and called the cops and blah, 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 right? The whole hoax thing, right? Those statements are statements of opinion, even though on their surface they appear to be facts. So how are they going to try to get there? They're going to try to get there by saying that Waldman's job is as an attorney, and he is communicating what he believes the facts will show at trial. Like this, the attorneys, by their nature, one of the things they do, especially in a trial setting, is try to say what the facts are, right? There's a whole bunch of evidence. And what I want you to the jury to conclude is these are the facts, A, B, C, D, E, F, G, right? And I'm going to present evidence. The evidence will show. The evidence will show blah. The evidence will show blah. The evidence will show blah. And the other side gets up and says, no, the evidence will show blah. The evidence will show blah. The evidence will show blah, right? So, but both attorneys are making statements of fact that they hope you, the jury, will ultimately adopt and ratify. And so they're trying. So what he's trying to say, what they're trying to say in this appellate brief, is that when Waldman was making these statements to the press, he was doing basically the same thing that he would have done if he were in a courtroom. It's like, these are the facts that I am purporting, and they are my opinion as to the facts. I don't know that that works. That's what they're trying to do. I don't know that that works. The statements in the court are protected by litigation privilege, which I think is a better argument here, that these statements are actually protected by litigation privilege, that they're in court enough to be protected by litigation privilege is a better argument. But to suggest that they are, because the whole concept of litigation privilege wouldn't make any sense if they weren't understood as facts, right? The entire concept of litigation privilege, that the lawyer is protected for the things they say in the courtroom, the entire concept of litigation privilege wouldn't make sense if they weren't understood as facts in the first place, right? If they were just understood as opinions, we wouldn't need the concept of litigation privilege, because we just say, well, they're opinions, and so therefore they're non-actionable, right? But we didn't say that. We didn't say, as a legal principle, we didn't say, oh, what the attorney says in court is a matter of opinion and therefore non-actionable. We said that they meet every test of defamation except for one, a state, which is one, that's they're privileged. They're privileged and therefore non-defamation. And right, the statements can be privileged. Statements made to your doctor in the course of treatment, statements made to your therapist in the course of treatment, statements made to your priest in the course of confession. You know, for examples of statements that would be protected by privilege, right? They meet every other test, presumably. They meet every other test of defamation. Statements of fact communicated to a third party tend to be injurious to the reputation, are injurious to the reputation, made with the right mental state of malice, negligence, or actual malice, as the case may be, right? They meet every other element of defamation. But there is that other element that we don't normally say explicitly because it very rarely comes up, the concept of privilege. And so the entire concept of litigation privilege wouldn't be necessary if the statements weren't understood as facts. We do understand them as facts. It's just that we also say on top of that, okay, they meet every other element of defamation, but they're privileged. So I don't think his argument works for that reason. But you know, we'll give it another try and see if he can convince me that this entire framework is wrong. But you know, okay, all right, we'll give it a shot. All right, so we'll give all that a try. The court should uphold the judgment in most respects, but reverse as the sole finding. I think because he's not actually an employee. I don't think Waldman is an employee. I don't think he can be an employee, and I don't think there's evidence of direction. That's the best argument. That the oracle didn't come in is also a pretty good argument, and then the rest is kind of eh. That these are statements of opinion? No, I don't think so. That they're protected by privilege is much better. Okay, anyways, Miss Heard mischaracterizes the jury's findings and facts, repeating factual claims that were unambiguously rejected by the jury. Heard takes the untenable position that evidence at trial established the party's marriage was falling apart due to Depp's alcoholism, drug abuse, and abuse of his wife. I don't know that the jury has to take an opinion on that one way or another, to be honest. Baffling, Heard spends many pages of her brief reciting a litany of factual claims that are necessarily found to be false by a jury in a wholly inappropriate attempt to re-argue. I don't know whether the jury found that to be false or not. I don't know whether or not the verdict is really enhanced by that conclusion or not. I don't know the jury had really an opinion on that particular issue or that matters one way or the other, but, fine. Heard's arguments failed the straight face test. The jury found in favor of Depp and against Heard on virtually all material points in dispute. I suppose implicitly that's true. In finding that Heard defamed Depp, the jury necessarily found that Heard's statement that she was a public figure representing domestic abuse, who had spoken up against sexual violence, made a false implication about Depp, and that Heard with actual malice when she made these statements, meaning she knew the implication was false. That is a true statement. That is definitely what the jury did. I mean, that much cannot be contested. That's true. Consistent therewith, the jury also found that Waldman's statements that Heard's abuse claims were a perjurous hoax and fake sexual violence allegations did not constitute defamation against her. Okay. The sole statement on which Heard prevailed include additional theorizing by Waldman. Yeah, it contained a lot of specific stuff. Arguably statements of fact, I think. And I also don't think those statements of fact mattered, which is another grounds you could appeal this on. Right? This is where me and the appellate lawyers of Brown Rudnick, I suppose, depart. Because rather than like this being an issue of opinion, which I don't think that works, better is litigation privilege, and also better, in my humble opinion, is the concept that there's just not enough daylight between reality and the statement to matter. So one of the things that we talk about in defamation, right, is that the statement is false, but it also has to be injurious, in which case the defamation has to make a difference. It has to matter in some sense, right? So I'll give you the cleanest example I can think of, right? Normally, if you said that if you say person X is a murderer and a person who commits violent assaults against women, right? Normally, if you said that and it was false, that would be a problem. Okay. But let's say you said, okay, this person has been convicted of 5 murders and 3 violent assaults against women. Normally, if that statement is false, that's a problem. However, if the argument is, okay, that's false because it wasn't 5 murders and 3 violent assaults against women, it was 3 murders and 2 violent assaults against women. So I've been defamed. Okay, on the one hand, yes, what you said was false. You said 5 and 3 and it was actually 3 and 2. So on the one hand, false. On the other hand, literally no one cares. Literally no one cares. There's not enough daylight between it. It just doesn't matter, right? There's not enough daylight between the defamation and the pleaded truth for anyone to care, right? How much more difference do you feel about this person? How much different do you feel about this person when I tell you they did 5 murders and 3 sexual assaults, and then you learn actually it was 4 and 2? How much more how much has your opinion changed about them? Was it a lot? Probably not, right? So one of the things I'd like to do if I were in their position is argue this idea, right? His statements, while maybe false, there's not enough daylight between that and reality for anyone to really care about, and so we shouldn't care about it. I think that's a better issue. I'm not saying that's necessarily a winnable issue, but I think it's better than one of the issues they picked. And that's one place I would have split off with Brown Run. Like I would have brought that in as like, there's just not enough daylight here for anyone to care. Is that a winnable issue? I don't know. It's still not as good as issue number 1, but it's better than some of the issues they picked. So, in my humble opinion. Okay, the sole statement on which Heard prevailed include additional theorizing by Waldman that Miss Heard and her friends set Depp up by calling the cops, spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed the second call to 911. See, that sounds like a lot of statements of fact. I'm not sure I care about those details, but, sure. The only intellectually honest interpretation of the verdict is the jury found that Heard's claim she had been abused by Depp was false, but also found that she had not conspired with her friends, lawyer, and publicist. That's pretty correct, right? The jury must have found for the verdicts to be reconciled, it must be true that they found the specifics of the statement to be false. And that was enough in their view somehow. Ms. Heard's attempt to recharacterize the verdict as consistent with her claims is untenable. Yeah. That is the best way to reconcile the verdict, so they both make sense. They believe that Depp was a victim of domestic violence and also believe that Heard did not do these things in this specific way. And that, at least for them, was enough in some way. Okay. Could be. Could be. Heard's reliance on vicarious liability based on agency is inappropriate in the attorney-client context. An attorney is properly understood as a non-servant agent, independent contractor. Yeah. Unless they are in-house counsel for a corporation, then they are an independent contractor. I think, yeah. I think that has to be true. I don't think there's any other situation in which an attorney acting as an attorney is an employee other than in-house counsel. And we could even have an argument about that. Miss Heard's, thank you very much for your nice super chat, Duncan Tate. And also there was a super chat earlier from, let me see if I can find it real fast and acknowledge it. There's one from Hooligan. Thank you very much. Appreciate that very much for all your super chat contributions. And I like the fact that notifications are going on the screen. That pleases me very much. Great. Ms. Heard's brief proceeds from the flawed premise she can prove Depp's liability merely by establishing that Waldman was his agent. Heard misses the point. The question is not whether Waldman is an agent, but rather what type of agent. Fair. Thank you very much, Pandora, for your nice congratulations for passing the Texas bar. Yes. As I'm sure many of you know, I have been a licensed Virginia lawyer for 15 years. So this brief comes from my state of admission, where I've been a lawyer 15 years. And recently, like, what was it, Thursday or something? No, it was Friday. No, it was Thursday. Well, Friday I actually got the bar number. Friday I finally got my bar number. And so I'm a real Texas lawyer. So how you doing? Yeah. So now I'm admitted in both Texas and Virginia. Hey. Okay. Yeah. So what type of contract, what type of agent is the right question? Virginia law has long drawn a distinction between employees and independent contractors for vicarious liability. This reflects the well-recognized principle it's reasonable to impose liability on a principal for the actions of another person if that person's under the principal's control in a meaningful sense, but not otherwise. In other words, the logic of generally holding employees liable for the torts of their agents or employees is simply that when an employer has the right to control employees, they are at least theoretically in a position to prevent them from committing acts. Less control an employer can exercise, less strength the logic has. It's about right. Although the Virginia Supreme Court is not squarely concerned the type of agency that exists between an attorney and client, there are substantial reasons to adopt the view of multiple other jurisdictions that attorneys, while undoubtedly agents of their clients for certain purposes, are presumptively non-servant or independent contractor agents. I think that is right. I think that is definitely correct. This is because attorneys are required to exercise independent professional judgment and are subject to independent professional and ethical obligations. Very true. Though guided by their attorneys with respect to the ends, attorneys have wide discretion over the means. That is definitely a very true statement. That is the principal distinction. That is the principal separation between the lawyer and the client. Also, incidentally, probably equally true for doctors and pretty much most professionals, to be quite honest, right? I don't think this is necessarily any more or less true of attorneys than it is of any other professional, right? If you go to a professional of any kind, a car mechanic, a plumber, a doctor, a lawyer, a florist, I don't know, whatever. If you go to a professional of pretty much any kind, you say what you want to have happen, but it is the professional who actually sets about how to do it, right? Like the mission, you go to the lawyer, the mission is, I'd like to win my case. You go to the doctors, I'd like to have my gallbladder removed. You go to the car mechanic, I'd like my wheel to stop wobbling so much, and so forth and so on, right? So the client sets the goal. The professional sets the method of execution, right? And then if you try to tell the professional how to do it, most professionals get really, really mad. And that's equally true among attorneys. It's like, you hired me, so we're stuck together, and I'm going to do it this way now. These factors preclude the level of control by a client that would justify imposition of vicarious liability. Pretty true. Agency is a fiduciary relationship arising from manifestation of consent by one person to another that shall act on his behalf and subject to control and the agreement by others so to act. That's basically what an agent is in so many words. You hire someone to do a thing. Importantly, the principle exercises control over the agent is not defined rigidly to mean control over the minutiae of the agent, such as the agent's physical conduct, as is required for a master-servant relationship, and may be very attenuated with respect to details, though the principal must have ultimate responsibility to control the end result of the actions. An independent person who contracts with another to do something for him but is not controlled by the other, nor subject to the other's right of control with respect to physical conduct, is in the performance of undertaking. He may or may not be an agent. Yeah. While it's always the case that this is coming from Arizona, this part. While it's always the case that an independent contractor is not a servant, it is not always the case that an independent contractor is not an agent. An agent who's not a servant, therefore, is an independent contractor when he contracts act on account of principle. That makes logical sense, right? So the independent contractor may be your servant and is your servant with respect to the goal to be achieved and perhaps some other things, but not really the means there too. Ms. Hurd incorrectly claims that Depp is arguing that Wallman is either an independent contractor or an agent. Hurd also appears to suggest that finding of agency relationship is incompatible with independent contractor status. That doesn't really make sense. Thus, she argues, because Wallman is an agent, an adequate basis for Depp's vicarious liability has necessarily been established, irrespective of whether Wallman was an independent contractor. Hurd, for instance, cites Petrovich versus Share Health Plan of Illinois For the proposition that vicarious liability for an independent contractor's conduct is permitted based on agency principles. But the theory the court adopted was that the employer of an independent contractor physician could be held liable under the theory of apparent authority, a position that's not been adopted in Virginia in the context of tort claims. Okay. So yeah, some states hold you liable for apparent authority as well as actual authority, but Virginia is not one of them, right? Only actual authority will do, not apparent authority in Virginia. Okay. Moreover, Petrovich did not involve an attorney-client relationship, and other cases from the same jurisdiction have considered that issue to conclude that attorneys are independent contractors whose clients are not automatically liable. In Horowitz versus Holeblad, Bird, for instance, court distinguished Petrovich in the attorney-client context as follows. A person may be both an independent contractor and an agent with the authority to bind the control of details of work, and also the power to act for and bind the principal in business negotiations within the scope of the agency. Within the scope of the agency. The nature of the agency, when you make someone an agent to do a thing, the agency is constrained by the thing, right? If you hire a mechanic to fix your car, he is your agent for the purposes of like ordering parts and stuff, but not so much for other things that would be completely outside that role. As a general rule, attorneys fit squarely within the category. Nonetheless, when attorneys act pursuant to the exercise of independent professional judgment, they possess such considerable autonomy over details and manner of performing their work. They're presumptively independent contractors. This very much is true, right? This very much is true. Different professions may be to differing degrees, but this is very, very true in doctoring, and I imagine lawyering, and I imagine many other professions as well that are consistent with this, right? You go to a doctor to have your gallbladder removed. You don't then go into the OR and say, I want you to use this kind of scalpel, and I want you to make the incision here, and I want you to use this kind of equipment and do it this way. And that no one does that. And if they did, they wouldn't let them, right? No one's going to let Karen into the OR. You're right, to supervise. Right, Karen, you can wait your ass out in the waiting room, right? So the mission is remove the gallbladder, but all the details are subject to the doctor's control. And different doctors do it different ways. And there are many different possible ways to do it. They use this kind of suturing or that kind of equipment or whatever, right? They do it in this order or that order, different their style, even in medicine. And same is true for an attorney. It's like if you hire an attorney, different attorneys will work with you to different degrees on the details. But strictly speaking, by principles of ethics, they don't have to work with you, right? Different attorneys will do this to differing degrees. But if an attorney tells you, like, okay, the last decision you got to make in this equation was you hired me, and that was the last decision you got to make. So, wait patiently, and we'll let you know how it turned out. And if that's the way that attorney wants to roll, strictly speaking, they can do that. And most attorneys are not that strict about it. And we've definitely seen the danger from Elaine about going too far the other way, about surrendering too much to the client, allowing the client to make too many decisions, allowing the client to make too many strategic and tactical calls. Right? It goes for a worst result. So, different, and I think attorneys are properly jealous of their own autonomy. And I think again, generally speaking, you want an attorney who will tell you no, because if you have an attorney who will only tell you yes, well, that's probably not a good thing for you, to be quite honest. Yeah. Yeah. Accordingly, when a plaintiff seeks to hold a client vicariously liable For attorneys' alleged intentional tortious conduct, a plaintiff must prove facts demonstrating either the client specifically directed, controlled, or authorized the attorney's precise method of the work, or the client subsequently ratified the acts. That makes sense. Like direction, control, ratification is where you basically adopt it on the back end. So yeah, that makes sense. That makes sense. The court in Hurwitz also noted the importance of attorneys' ethical obligations, which severely limit the level of control their clients can exercise over them. Attorneys are constrained by certain court-imposed ethical consideration that serve to distance their behavior from clients. Thus, attorneys cannot blindly follow their clients' directions, even if those directions are particular and express, if doing so would require them to violate their ethical obligations. Yeah, and not only for ethics reasons, but pragmatic reasons. Right? Because whether or not Elaine violated her ethical guidelines, I'm not going to take a position on at this time. But it was for the worst. She does have the ethical guideline, Rule 1.1, as competency to competently and zealously represent the client. And turning things too much over to the client might interfere with that duty. So there's ethics reasons that an attorney can't do it, and there's also pragmatic reasons. And also, like, you hired me, so, yeah. Yeah. Although there are some jurisdictions that will impute tortious conduct from an attorney to a client based solely on the agency relationship, normalist courts have concluded the agency alone is not sufficient because attorneys are independent contractors with considerable autonomy and discretion. I think that's the better way of thinking about it. That's a better way of thinking about that. Here's a case from Texas. A defense attorney as independent contractor has discretion regarding day-to-day details of conducting the defense or case in general, and is not subject to client's control regarding the details. Yeah. I'm surprised that there are courts apparently that have gone the other way on it, but apparently someone did somewhere. That approach is most consistent with the core premise of vicarious liability. And it should be based on the right of the principal to control the agent and prevent tortious conduct. And the court should adopt that role. I tend to agree completely. I think this is a much better way of thinking about the issue for the reasons we've discussed. A lawyer is a professional, and lawyer is hired by the client to do a job. How the job is conducted is up to the lawyer. And the client's the client's input in that role is somewhat minimal, and it should be somewhat minimal, to be quite honest, because, well, the client doesn't know what they're talking about. That's the reason why they hired them in the first place, right? So, yeah, thank you, Chibi, very well for the super chat contributions. I appreciate that very, very much, and everyone who helps to support the channel. I appreciate everyone who's here. As always, I appreciate all of you who are here. Thank you very, very much. Yeah. All right, great. Let's see. Where were I? Okay, great. Let's see. Thank you, Karina. I appreciate that. Whether Waldman was an independent contractor is especially critical inquiry in defamation context. Several courts have concluded that First Amendment restricts imputation of actual malice in the absence of the employer-employee relationship, and the existence of a mere non-servant agency relationship is not sufficient. For instance, the U.S. District Court for the Eastern District of Virginia, and whether or not Virginia will pay any attention to that is anyone's guess, with respect to agency theory, It is well established that actual malice must be proved with respect to each defendant. Although reckless disregard may have been imputed to a defendant under respondeat superior, that's the employee-employee relationship. Yeah, I took care of the bot. That's why I had to sing for a second, because I had to go and change the setting, but we got it. Multiple courts have held that actual malice cannot be imputed from one defendant to another, absent an employer-employee relationship. The imputation of actual malice was examined at some length by the court in McFarland versus Esquire in the District of DC. The question in McFarland was whether the malice of a non-employee agent can be imputed to the principal. Shelly Babes says, by the way, I would so date you. Well, Shelly Babes, if you would like to reach out to me or any other women in chat who are interested, then please feel free to write me an email. You can write me at kurt@uncivillawllc.com. My contact information is available on my About page as well, in case you forget. And I look forward to hearing from you. And I just noticed that my camera is ever so slightly zoomed in. I wonder if I can fix it real fast. Hold on. How do I? Where's the zoom setting on this thing? Aha! Thank you, and for your nice happy Hanukkah message. I appreciate that very much, Anne. Thank you very much. I appreciate it. The court noted that in the seminal case of New York Times versus Sullivan, the United States Supreme Court had refused to impute to individuals as principals any information in the minds of persons they author to act as agents in the matter, and federal courts commonly interpret the Supreme Court's holding in Cantrell as barring liability on a theory other than respondeat superior. Okay, I'm liking these citations. This is working for me and amplifying the idea that okay, that especially in the context of attorneys, there's some special protection there. So we got some authority for that proposition. A proposition I was a little bit dubious at the front end, but that's okay. That's why we read these things, and then they teach me things, and I'm like, okay, that sounds right. And we see some citations and some authority for the proposition that yes, attorneys should be viewed in a more skeptical light in this respect, as opposed to other professionals, because of the nature of what attorneys do and the nature of their ethics and so forth and so on. I'm like, okay, great. Tonight's the first night of Hanukkah. I did not know that. Put on that yarmulke. It's time for Hanukkah. Here for lawsuit Yannicka. Uncivil Hanukkah. Johnny Depp is not a Jew, but he filed an appeal, and we're going to read it too. Anyways, the McFarland court The McFarland court ultimately doubted that actual malice can be imputed except under article respondent superior, and held a principal's malice could only be established through evidence of information available to and conduct of its employees. As even Miss Hurd appears to concede, Wallman was never Depp's employee and respondent superior does not apply. Yeah, I mean that's yeah, I think we're there. Yeah. Yeah, don't feel shy, Shelly Cat. To feel free to tell your friends about tell your friends about me. I'm available. I am I I'm available. I am a licensed attorney in 2 jurisdictions, and hey, you know that I must be decently okay because I just passed character and fitness review again. So like I'm not like I don't have any problems there. I'm an attorney. I have a successful YouTube channel, 121,000 subscribers. Thank you, by the way, for every one of you who's subscribing, which by statistics puts me in the top 0.3% of YouTube. I have more subscribers than 99.7% of YouTube channels. So hey, I'm succeeding and actually making money doing it. I'm I like to think fairly intelligent, well read, well understood, and can explain things. And I'm good at dialogue and conversation, and I'm loyal. You know, just saying. I'm available. I'm a good catch, right? Also, I can cook. I made a great vegetable chicken stew thing. That was really nice recently, and I make a pretty decent beef Wellington. So you know, hey, I can do a little bit of cooking and stuff, and you know, it's good times. So Kurt at uncivillawllc.com. Kurt at uncivillawllc. If you're a girl or know a girl who would like some of this, you know, holla. Also, I have a song in my heart. Ah. Where do you send your application? Kurt at uncivillawllc.com. Kurt at uncivillawllc.com is where you send your hat, or you send your not your hat, send your application. Okay. Let's see. Miss Heard did not establish that Depp directed, controlled, or authorized the April 27th Waldman statement. And I do have a nice hat. Thank you. Because liability was based solely on Waldman's status as Depp's outside attorney is inconsistent with long-standing Virginia principle limiting liability of employers of independent contractors, Heard should have been required to establish tortious conduct by Depp beyond merely employing as an attorney. I think that's true. I think that is true. Heard did not do so. Although Heard made a conclusory assertion that Depp entrusted Waldman to be his mouthpiece in continuing to defame Heard through public statements, there's no actual evidence of that in the record. Indeed, the response to a question from Heard's attorney, Waldman made clear the relationship with Depp is simply that of an attorney. Though Waldman acknowledged speaking to the press, yeah, and then there's this little footnote here that does seem to be the proposition that Heard is taking. Heard appears to take the position that speaking to the press presumptively falls outside the normal attorney-client relationship. Yeah, that is definitely that's definitely a fair thing to conclude from her opinion. So stuff like that, yeah. Also, I smell good. I have a collections of cologne. I have a nice little collection of colognes, and I can talk to you fairly intelligently about the colognes as I have before, and I can tell you like the different things that are in the colognes and why they smell good. And also, I have a little bit of watch collection because I like watches, and I can talk to you about watches and how they work and why, you know, springs and, you know, regulating mechanisms and stuff. So you know, I got that going for me. I've got nice lighting. You got lighting set up. You know, I've got a nice car. An Infiniti FX35, in case anyone cares. It's their SUV, and I love it very, very much. And I went to the gym today. I went to the gym today, and I went to the gym yesterday. and I had a good workout, so I'm trying to take care of my health. You know, it's all right. Though Waldman, now speaking to the press on several occasions, that does not constitute. Seth has improved greatly over the year. Thank you, Joshua. I do try to make steps to improve things. I appreciate that. Thank you. If I'm ever in the south of England, pop by. Do I like redheads? Of course I like redheads. I am a redhead. Looks a little more brown on camera, but what are my expectations from a woman? Well, I'll tell you what I'm looking for. I've told you before. First of all, I'd like to have biological children. So, as a result of wanting to have biological children, as a practical matter, because I assume that we all can be honest about things, right? That we are aware of the various curves when it comes to like women having children, particularly as it relates to ability to get pregnant and also the rates of birth defects. Because of those factors, which I don't need to go into depth about, but we acknowledge as a reality. It would be probably helpful if she's not older than mid 30s, because by the time we, have a successful courting relationship and get married and have kids, right? If she's already in mid 30s, by the time that all that happens, we're pushing 40, and that's a factor, right? 40 is a notable point on the curves I alluded to. So first of all, it would be very helpful if she's not older than mid 30s. In terms of what I'm looking for beyond that, I'm looking for someone who, first and foremost, I want someone I can talk to, because marriage, to my mind, is conversation. Because I mean, you're literally spending lots of time with this person. You literally have to be able to talk to each other in a literal sense. So, like, the first thing is that, well, beyond beauty, which I think is implied, but I like someone who is nice to look at. But obviously, beauty only goes so far, um, and beauty fades, of course. But beyond that, I want someone I can talk to. I want someone I can have an intelligent conversation with, and someone who's curious about something. It doesn't have to be law. Something, any field. In fact, if it's not law, in some ways that's better, because it gives me something new for me to be curious about, right? So if she's like a doctor and really likes being a doctor, or just as a hypothetical, and she really likes that, and she really likes her field, that gives me something to learn about. It gives me something to have a conversation about and learn about, and her excitement in her field of interest will inspire me, and hopefully the reverse. So I want someone who is passionate about something and likes to learn more about that subject and likes to be a master in that subject. And it could be just about anything, right? Because it doesn't have to be law. It would be, I would appreciate it if she's interested in the fact that I'm interested in law. She doesn't have to be interested in law herself, because that's what I like to talk about. So hopefully she likes listening to that, because it's what I like talking about, and I can listen to what she has to talk about. So someone who is intellectually curious, I think would be a very strong trait. It would be helpful if she has formal education, although not necessarily required if she can show her desire to learn in some other respect. But formal education is helpful. Um, let's see what else. Um, I don't want anyone who already has kids, because I think that overly complicates a relationship. Um, I've tried dating people who have kids, and it never seems to work, and I think that's probably not really great. Um, someone who's kind, loyal. I want someone who's loyal. Um, preferably more introverted. Although I do like going out to things, but not someone who like always has to go to parties all the time, because that would be tiring for me. So someone who's more introverted. Um, Probably someone who's more politically conservative would be helpful. You think I should invest in a matchmaker? Okay, which one should I invest in? Um, Liz, which one should I invest in? But sense of humor, yeah, that's good. Is religious? Religious is not super important to me. I don't consider myself particularly religious. Um, yeah, that's kind of what I'm looking for. I am going to be 42 in January. I'm going to be 42 in January, and yeah, so that's kind of what I'm looking for. And at the moment, I live in Austin, Texas, but I'm willing to relocate for love. I prefer dogs to cats. Am I a Capricorn? I am a Capricorn for whatever it matters. I don't really believe in astrology. Prenup, it doesn't probably, probably just, for the sake, yeah, but I'd like to not have to worry about it too much. I'd like to not have to worry about getting divorced. Would I convert? Maybe. How's my health? My health is very good otherwise. My blood work, all my blood work is bang in the middle. So I have no health issues right now. Um, okay, let's go back to the stream. Okay. Do I want a son or daughter? I don't really care either way. Farm life could work. How many kids do I want? It's negotiable, probably 2 to 4. Um, but I'm open to other possibilities. Will she has fertility issues? Well, that's part of the risk you take and just hope for the best, I guess. Does race matter? Not if I find the right person. Now, the uncontroverted evidence of trial was that Depp did not even know the statement was made until Heard commenced the action. The sole basis of finding liability against Depp based on the April 27th statement was therefore that Wallman was his attorney and agent. Such a finding is inconsistent with legal principles applicable to independent contractors and should be rejected. Non-smoker for sure. Non-smoker for sure. Yeah. It is well established in Virginia law that a claim cannot proceed against the employer or principal based on an employee or agent's conduct without showing that employer or agent committed the tort. Am I tidy? I don't like to think I'm pretty tidy. Ignoring these authorities, I've definitely gotten tidier over the years, that's for sure. Ignoring these authorities, Heard argues that court can find a complete tort by mixing and matching the conduct of both a principal and agent. Here, that means stitching Depp's supposed state of mind onto Wallman's conduct to find against Depp, even if Wallman's conduct did not satisfy all the elements of tort of defamation. That is not permitted under Virginia law or any law. I don't really think that's really good. Do I snore? At the moment, I use a CPAP, so no. Ms. Heard's sole basis for her theory is language, the restatement indicating a principal can be held directly liable for an agent's conduct that is within the scope of an agent's actual authority or ratified by the principal, if the agent's conduct, if that of the principal, would be subject to torts liability. Come to Brazil, I'd be happy to come. How would I know if I snored if I lived alone? Sleep studies. I've had sleep studies done. That's how I would know. It wasn't so much that I snore as that I stopped breathing 300 times a night. That's not even an exaggeration. And my doctor thought that wouldn't be an issue. The stopping breathing thing. So yeah. So so the CPAP. Sleep apnea. Yeah, that's right. Would I be willing to move to Australia? Sure. Would I clean up joyfully after a messy girl? In which respects is she messy? An agent acts with authority when at the time of taking action, the legal consequence for the principal, the agent reasonably believes, in accordance with the principal's manifestations to the agents, that principal wishes the agents to so act. Yeah, the CPAP is totally quiet. It's whisper quiet. You never hear it. There are multiple problems with Heard's argument. First, it runs contrary to well-settled Virginia authorities, including those noted above, that make plain the liability of a principal or employee is contingent on showing the agent or employee committed the tort. Indeed, the Supreme Court of Virginia noted as recently as 2018 that if a mere employee commits tortious conduct, the corporate employer will not be subject to direct liability, technically speaking, but rather only respond to superior liability. In other words, absent showing that Wallman was acting at Depp's specific direction, Heard is limited to vicarious liability. Yeah, that's not going to work. Thank you very much, Admiral Nelson, for the nice super chat. I appreciate it. In other words, absent of showing that Wallman was acting at Depp's specific direction in making the statement. Okay, I read that. Second, a portion of the restatement cited by her. Don't give me a hard time, American legend. It came up and I was answering the chat's question. Jesus Christ. Second, the portion of the restatement cited by Heard does not salvage her argument because there is zero evidence that Wallman's statement were directed by Depp within the scope of actual authority. Heard does not cite any evidence in the record of any manifestations from Depp to Wallman instructing him to make the statement such that Wallman reasonably believed Depp wanted to make the statements. Nor has Heard identified any evidence in the record that Depp ratified the April 27th Wallman statement. Third, even looking over these defects, actual malice requires clear and convincing evidence of contemporaneous knowledge that the statement is false or probably false. Mr. Depp's uncontroverted testimony was that he would, prior to the litigation, and jury received no evidence to suggest he contemporaneously knew it had been made. Fair enough. Fair enough. Thus, even if Depp's state of mind could theoretically be mixed and matched with Mr. Wallman's conduct to create a Frankenstein tort, nice, there's no evidence from which it could be reasonably inferred that Depp had requisite state of mind. He knew the statement was false because he did not even know it's been made. Yeah, I find this very, very persuasive, this line of reasoning. I find this line of reasoning very, very persuasive. This is all going to legal principles, which is perfect for an appeal brief because that's what courts of appeal do. Right? These are not factual questions. Right? These are not factual questions. These are questions. Which holidays do I celebrate? I went home for Thanksgiving to visit my parents, and I like Christmas. I don't like Christmas music. Well, let me restate. I don't like traditional Christmas music. I don't like the Christmas music that you hear when you go into a store, because it's the same music every year for months, and it haunts my dreams. I like the Christmas lights though, and I like different covers of Christmas music. But if I hear "Rocking Around the Christmas Tree" one more time, someone's gonna die. Okay. Do I like art? Yes, I do have art. I do. I have a nice art. Do I watch sports? I watched the World Cup tonight. Today it was a great game. But sports are not normally my thing. I'm a Clemson football fan. Clemson Tigers, go Tigers. So I like to watch when they play, and they're playing December 30th against Tennessee. So I'm looking forward to that. In assuming the tort could somehow be imputed to Depp, Heard was required to establish that Wallman made the statement with actual malice, meaning he subjectively knew it was false or probably false. Do I watch Netflix? Not anymore. I don't. Not since the whole cuties thing. I got rid of my Netflix account because I didn't want to continue supporting them. I watch a lot of YouTube, and I don't have cable TV. So I went out to watch the game. Um, you think I should? You think I should buy a billboard? Yeah. You think I should buy a billboard to find a woman? I don't know if that's the way to go, man. Even assuming tort could somehow be imputed to Depp, Miss Heard would be required to establish that Wallman made the statement with actual malice, meaning he subjectively knew that was probably false or false. In order to establish actual malice, the plaintiff must demonstrate by clear and convincing evidence defendant realized the statement was false or subjectively entertained serious doubts as to truth of the statement. Evidence of mere hostility, failure to reasonably investigate, or lack of proof are not sufficient. They are certainly not. Yeah. Would I consider giving up Clemson for Ohio State? Do I have to give it up? Isn't it enough that I cheer for Ohio State whenever they're not like playing each other? They're not even in the same conference. Isn't it enough that I just simply cheer for Ohio State whenever they're not playing Clemson? I promise I won't remember how many points Ohio State got when it played Clemson in the college football playoffs. I promise I won't remember how many points Ohio State got in that game. Lol. Miss Heard is unable to come up with any serious arguments to the contrary. She argues that Wallman could not seriously be believed, that there was no damage to the penthouse, and that Heard had caused damage to the penthouse described in the statement. This, from my perspective, why am I still single? I'm just really bad at game, despite my attempts to learn game. I think is the answer. I'm not a natural at it. And when I try to talk to women in general, when I meet them, it winds up in small talk. I'm not really good at game. And I've tried to learn and stuff. And, just, yeah, I think that's probably the reason. I'm picky. I don't think I'm that picky. At trial, Heard asserted there was evidence of damage to the penthouse, supposed damage that Wallman explained in a statement suggesting she had done herself, while noting the police officers called to the premises had seen nothing to support her allegations. This is not clear and convincing evidence that Wallman subjectively believed his statement was false. To the contrary, the evidence overwhelmingly indicates that he believed what he said. Similarly, Heard complains that Wallman selectively credited only evidence he believed was favorable and ignored the abundant evidence of Depp's abuse of Heard. Again, that is a feeble argument and directly contradicted by the findings of the jury against Heard. Waldman is entitled to make value judgments against the weight of the evidence, just as the jury did, and both Waldman and the jury conclude that Heard was not credible. The fact that Waldman rejected Heard's version of events is not clear and convincing evidence of subjective knowledge of falsity. I mean, as to that element, I'll agree with you. Ms. Heard has not pointed to and cannot point to any evidence in the record to permit the conclusion. By clear and convincing evidence, am I a romantic? Yeah, I think so for sure. Am I a good listener? Yeah, I think so. I think I'm both those things. I'm a romantic. I think I'm definitely a romantic. I always get a little sad when I read about someone's divorce because I always want to work out in the end. You know, I'm a sucker for the they ride off into the sunset and live happily ever after kind of thing. I always get a little sad when I read in the news that some people are divorcing, because I'm like, I'm definitely a romantic. Yeah. And I like to think I'm a very good listener. I'm also a very patient teacher. So Kirk can listen to Sotomayor for hours. He can listen to anyone. Yeah, I think I'm a good listener. The statement is properly understood as opinion. I'm not sure about this. Context is crucial in determining whether a statement is defamatory. That much is true. In arguing the statement is factual, Heard largely ignores the statement was made to a reporter who wrote articles laying out the statements from representative of both sides of Depp's and Heard's dispute. Heard contends the statement made by a journalist cannot render Waldman's statements less defamatory. That's not the point. The statement was made to a reporter who clearly recognized it and presented it as opinion, not fact. Maybe in the context of the whole article, maybe. Looks like I'm ready for a nap, but actually I feel pretty good. I'm not an outdoorsy kind of guy. I have been whitewater rafting and I do like that. And I wouldn't mind like a short hike or something like that, but I'm definitely not a camping kind of guy. I'm not a let's get in the RV and go tour America kind of guy. I'm a can I get a hotel kind of guy. Outdoors is not outdoors is not really my thing in principle. I like going to wineries and distilleries and breweries though. And I do like sitting outside. So I do like sitting outside a winery and like there's a guy playing guitar in the background somewhere and listening to the guitar and drinking some wine and listening to the birds chirp. That I like. Significantly, Waldman never claimed personal first-hand knowledge of what transpired between Depp and Heard. Rather, the statement is commentary by lawyers on inferences to be drawn from conflicting evidence in contested litigation, which is discussed in the article. The subject matter of statements and Mr. Waldman's relation to that subject indicate that statements were non-actionable opinions. How tall am I? 6 foot. A reasonable listener would recognize Waldman's statements in context as a lawyer advocating for his client's position by proving a theory based on disclosed evidence of what happened, not a factual statement based on personal knowledge. I'm not sure about that one. Whether a person hides cider company, that sounds pretty badass. Stop trying to make me fall in love with you, but that's the whole idea. Whenever I want you to fall in love with me, I'm lovable. Whether a person is an employee or independent contractor can be determined as a question of law when as the facts compel one interpretation. Otherwise, it's a factual question. On the facts of this case, Wallman is an independent contractor whose allegedly tortious conduct should not be imputed. The judgment was therefore error as a matter of law. I think that's probably right. At a minimum, there was sufficient evidence in the record to permit giving the jury instruction on this point. The evidence at trial established that Wallman represented Depp as an attorney in various litigation matters, but in no other capacity. And Wallman is the owner and managing member of his own law firm, which offers legal services to clients other than Depp. These facts plausibly support the conclusion that Depp's control over the details of Wallman's work was limited and could support a finding by the jury that Wallman was an independent contractor. A jury instruction on the issue would not have been duplicative, but rather purposely focused the jury on the core issue. I'm feeling it. I'm feeling it. Ms. Heard's argument that the April 27th article was properly admitted in redacted form misses the mark. The article was not offered for any hearsay purpose, but two separate and significant reasons. It is established the reporter did not accept Wallman's statements at face value, undercutting the notion they were defamatory in context. It was relevant to assessing what the damage, if any, Heard suffered. Without the full unredacted article, the jury was forced to speculate on damages without being able to make a forced assessment of the promise of the statement. Yeah, I think that's right. I think that's right too. My email address is kurt@uncivillawllc.com. Uncivillawllc.com. Kurt@uncivillawllc. What makes me laugh? My favorite comedian is Mitch Hedberg. And I've been told I have a very British sense of humor. Notably, the statement contained in the article with prominent headline exclusive, I need to report an assault. Listen to 911 call the night Johnny Depp and Amber Heard had a blow-up fight that ended their toxic 18-month marriage, but both claim the tape backs up their version of events. The April 27th article lays out both sides of conflicting versions of events. If you go to the gym, we can go to the gym together and work out together. That'd be fun. So, because I can use a gym buddy. Work out at the gym, work out at home. Try to have a one night stand or for a New Year's party. Now you call her wife. That's very, very cute. Do I like cinnamon roll incense? I suppose. The April 27th article lays out both sides of conflicting events. Do I have a hobby that involves my hands? I like pistol shooting, and I've been to the gym several times. I was at the gym today. I was at the gym yesterday. Am I 420 friendly? I've never indulged myself. I don't know. It's never come up. Favorite movie? Thank You for Smoking is my favorite movie. The April 27th article lays out both sides of conflicting versions of events, noting that Miss Heard's attorney says phone records and police department logs vindicates Heard's accounts of final shocking episode of domestic violence she endured before filing for divorce. Whereas Mr. Depp's legal team say this recording does the precise opposite. However, by raising discrepancies in the various accounts Heard and her allies have given of the notorious dust-up. It also describes Miss Heard's various allegations of abuse, Wallman's rejection of credibility, and response from Heard's attorneys calling Wallman's statements fantasies. It is relevant to damages analysis that Wallman's statement was not presented to the public as uncontroverted fact. Moreover, as noted about what's better, chocolate or vanilla? I think I'm going to have to go vanilla. Really nice vanilla, a really nicely made vanilla is pretty enjoyable. Yeah. You passed concealed carry? Oh, that's cool. Oh, it's from the movie. Yes, that's true. What's better, chocolate or vanilla, where they had the debate on that? That's true. It was from the movie. That's true. I didn't make the connection in my mind, but you are correct, sir. They asked the question. They asked the question while they were at the fairground with the merry-go or the Ferris wheel running in the background, and then I think they had the ice cream on the Ferris wheel, if memory serves correctly from that scene. It's KURT. KURT. It's relevant to a damages analysis that Wallman's statement was not presented to the public as uncontroverted fact. Moreover, as noted above, a relevant inquiry in what oysters are chocolate. What? It's relevant in assessing whether the statement is defamatory, is whether the statement was made to someone knowledgeable about the facts and capable of recognizing the statement as opinion, rather than an objective, reliable fact. The content of the article is evidence that Wallman spoke to a journalist he understood was hearing one side of the story that had two sides, as a journalist presented both sides in the article. Further, the fact that the article contains so much additional commentary about both parties would have been relevant to enable the juror to assess the likelihood that Heard suffered any actual damage as a result of the statement as appeared in context, or whether any support damages were attributable to many other statements. The full article should have been admitted. I tend to agree on that too. Yeah, I tend to agree on that. Yeah. Thus, they respectfully submit that. Yeah, I think that's right. So I think some of that's right. I'm not so sure about the opinion thing, about the Wallman statements being opinion. That's an interesting take. I don't know about all that. But yeah. I don't know about all that, but yeah. But a lot of that was pretty good. If the full article should have been admitted, I tend to agree. That Wallman cannot be a employer, and there's no signs of directions. I tend to agree. So I think I agree as to the conclusions, or the conclusion that the thing should be set aside. I think that's pretty good. I really like the way that brief was written personally. I thought it was very good. Let's see. Today we had some super chats. Today's the 18th. Your super chats are the following. Don Conte gave $10 to say, well, actually before that, Hooligan S3 gave $20, thank you very much, to say, Sergio, law only, the good, the bad, and the uncivil. Hat Kurt for the win. Don Conte gave $10 to say, thank you for sharing your legal knowledge with us. You're welcome. Melinda gave $10. Thank you very much, Melinda. $5 from Chibi Peach. I pay you, do as I say, doesn't it generally well. That's true. 10 Canadian dollars from Ann Lieberman, who said Happy Hanukkah. Happy Hanukkah to you, and Happy Hanukkah to our Jews everywhere. Put on the yarmulke, time for Hanukkah. Sun civil laws, Streamacon. Well, first night of Hanukkah, uncivil law, not a Jew. Tim Pool's yarmulke beanie gave $2 to say, did someone say Hanukkah? Chibi Peach say, shit, it's in my head now. Well, my co-worker's gonna rue the day. $5 from Chippy Peach says, it's good to know what you want. Straightforward and honest is best in everything. Not everyone agree, but the right person will. Good luck. And Admiral Nelson gave $10 saying, Merry Christmas, Kurt and chat. May God bless you all in the next year. Well, that's a very nice thought. I appreciate that. Thank you very, very much. I appreciate the your kind support and thoughts as always, because you guys kick ass. American Legend gives $5 to say thanks for being Kurt and streaming with law knowledge. You're the man. Thank you. You can tell I've lost weight. See it in my face? Well, thank you very much. I appreciate that. Thank you very much, Don Conte, for the 5 gift memberships. It's very, very kind of you. Thank you very, very much. That is super, super awesome. Thank you very, very much for that. It's kind donation of memberships. Do I know how to play euchre? No, but I certainly could learn. Be the Riz master that you are. Okay. Chess, I do play some chess. Get my ass kicked in chess, but I do play some chess. Do I know sign language? Not in particular. I could try to learn. I should do stress chess streams playing viewers. Oof. Do you believe she's out there? I hope so, man. I hope she's out there. She can come up behind me while I'm streaming and give me hugs. Do I play bridge? I don't really play any card games except for poker, and I haven't played poker in a long time either. Well, my friends, the 700 of you, do I have any pets? I don't have any pets right now. Ever shoot bowling pin matches? I've never shot one. No, I've shot steel, shot steel, but never bowling pins. But what do I do for fun? Stream, go to the gym, read. Sometimes go to wineries and distilleries. I do Toastmasters sometimes, public speaking, improv, comedy. I did a lot of improv when I was in Virginia, and I'm going to try to get back into improv in the new year. Do some improv comedy. I like improv. It helped a lot with streaming. So do some improv comedy again. That'll be fun. Yeah. What would I consider fun with a partner? Sitting at home together, being in each other's company, I'd consider to be fun with a partner. I've sent you an email business at. I couldn't find another email. Business also works. Business at Uncivil Law LLC or Kurt at Uncivil Law LLC. Either one's fine. What am I doing for Christmas? No plans right now. What hobbies would I like my partner to like? I don't know. I don't think it really matters too much. Is this chat trying to hook Kurt up? Yes, very much. This chat's trying to hook Kurt up. That's definitely what we're doing. Do you want her to work or stay at home mom? I think I'd want her to be stay at home when the kids were young in particular. I don't know how I'd feel about that on a more ongoing basis, but I think kids, particularly when they're young, need a lot of parental support. And because most of the thing, you need to make sure they're off to a good start. So I would think, before in their first formative years, I'd want her to be more stay at home. After that, I don't know. But that would depend on her career and her interests and stuff. So it would be something we'd have to work through. Yeah, if she has a career, if she has a career, it's something we'd have to discuss. That's something that's going to be more of a discussion on a one-on-one. I think that's going to depend a lot on a lot of things. All right, I'm going to sign off for now, guys. Again, my email address is kurt@uncivillawllc.com or business at uncivillawllc.com. Either one's fine. I've been Uncivil Law. Thank you for all your interests. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.